All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director at the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Military Retirement Division and Divorce, a guide for legal aid attorneys. Before I introduce our speakers, I do want to go through the typical housekeeping announcements. This training is being recorded. We're going to be posting it on YouTube. If you're registered, you're going to receive an email from Zoom within 24 hours. If you're subscribed to our YouTube channel, you will be notified as soon as it's posted. Usually, I'll have it posted by the end of the day. You will also get a copy of the materials, a link to the materials that we're using today, along with the slides and other materials that our speakers are sharing. This training was approved for CLE by the Florida Bar for 1.5 General CLE and 1.5 Marital and Family Law Certification credits. So I'm going to announce the code towards the end. I know sometimes I forget, so don't worry. I'm going to drop that code into the chat as well. I will include it in the YouTube description, and it will also go out via the email from Zoom. So if for whatever reason I forget about the code and you need it, just feel free to reach out to me via email. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, just let me know and I'll reach out to you directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I highly encourage you to take a look at their website and social media. I'm going to be dropping their link to the website. There's a lot of great subject matter work groups and operating committees. There's the opportunity to work with experts, with law students. So I highly encourage you to take a look and consider joining PILS if you're not a member. And final piece of housekeeping announcements are questions and answers. For this webinar, we're going to encourage you, like if you have questions, feel free to use the chat. Don't worry about the Q&A feature. Try to use the chat and our speakers will try to address questions as they come in. If for whatever reason we miss it, we'll try to save some time towards the end if time permits to address those questions. So the another thing, this is a webinar format, so people won't be able to come off mute. So if you do have a question and you accidentally raise your hand, I'll let you know. Just make sure to use the chat. So with that said, I think that was the last housekeeping item that I had. So we're really welcoming back our speakers right now. We had them on. They led a great training back in April on QDROs. And if anybody knows what a QDRO is, drop it into the chat. Let's see if you learn what a QDRO is. And we also had an acronym webinar. But yeah, at this point, it's my pleasure to welcome back our speakers today. I'm going to introduce each one of them. So I'm going to start with Carrie. Carrie Holmes is the executive director of the Center for Access to QDROs, a nonprofit expanding access to retirement benefits for low-income family law litigants. A UCL law graduate and civic engagement honoree, Carrie brings a strong background in pro bono work and legal tech advocacy. She previously held leadership roles at the San Diego Volunteer Lawyer Program and Harriet Buhai Center for Family Law, and currently serves on advisory committees for the Judicial Council of California and Paladin. Louise Nixon is the board president for the for Access to QDROs and co-founder of QDRO Council, a legal tech company modernizing retirement benefit division. A national leader in QDROs, Louise advocates for expanding access for these services through technology and nonprofit partnerships. She has been recognized by the Pension Rights Center for her work on closing the justice gap in retirement asset division. And last but not least, our next speaker is Natasha Tang, a national expert in QDROs with over a decade of experience. She's prepared and reviewed thousands of orders across military, federal, public, and private retirement plans. Natasha also co-developed QDRO Council, a platform expanding access to QDRO services, and currently serves as the Director of Legal Services at the Center for Access to QDROs, supporting legal aid and low-income litigants in California and Nevada. So join me in welcoming our friends from the Center for Access to QDROs. And with all that said, Carrie, the floor is yours.
Thank you so much, Jorge. What wonderful introductions. It's lovely to be back with you all in Florida. We're so excited to talk to you all about Military Retirement Division. This is a very detailed area of the law. There's a lot going on here, but we have designed this presentation to really be focused on what do you need to know as a legal aid practitioner to make sure that you set your clients up for success in ensuring that they are able to secure their fair share of these benefits. The format of the presentation today is that I'm going to be kind of taking the lead, going through the slides, doing all of that. And Natasha and Louise are going to be chiming in. Both of them have an incredible amount of expertise and experience, specifically with military division orders. So we're really lucky to have them on our team. Um, as Jorge said, if you have any questions, please feel free to post them in the chat. We're happy to answer them as they come up. We'll try and leave time at the end as well, though, for questions. Okay. So today we're going to briefly talk a little bit about what we do at the Center for Access to QDROs. We are a nonprofit legal services organization providing free QDRO services to low-income litigants. We'll cover some military retirement basics. We'll talk about calculations that we might need to do. Don't worry, there's no math in this presentation. I know everybody likes to say I went to law school because I'm not good at math. We don't expect you to do any math today. But we'll talk about the information that we need in order to prepare the military retired pay division order. And then we're going to talk about a really important, really powerful piece of protection for your client, which is called the Survivor Benefit Plan, that has a lot of tips and tricks to make sure that it is secured properly for your client. Okay, so why is there a nonprofit that is focused specifically on QDROs? And we at the center see our work preparing QDROs for low income family law litigants as economic justice and poverty abolition work. QDROs are directly related to that kind of work, especially for women and seniors. There are a tremendously large number of older Americans living in poverty. And it's the rates of poverty in older Americans are even greater when you focus just on women. And as women grow older, the number of them living in poverty increases. So, accessing and securing retirement benefits are a significant and sometimes the only source of wealth accumulation and post retirement income for low income Americans, especially when we're talking about older women who may have taken time off from work to engage in caregiving activities or because of occupational segregation into lower wage work. Getting their share of marital retirement benefits is hugely, hugely important. And I come at this work sort of from the perspective of a family law legal aid attorney. So for me, it always felt great to get an awesome judgment that awarded my client a share of any kind of retirement benefits, only to send that client kind of off into the wilds with no ability to actually access those funds without getting a quadro done. So the center was born by Louise and Natasha and myself and others to fix that problem and make sure that we actually effectuate those great orders that you all are getting for your clients so they actually receive the money that's theirs. Okay. At the center, we offer a couple different kinds of services. Of course, we offer quadros. That's our bread and butter. We're out here slinging quadros every day. But we also do a lot of other kind of related to quadro work that I think is really important. So, one of the most crucial things that we do is plan research. And we at the center have access to an enormous database of retirement plans. It has nearly 1 million retirement plans in it. And what's really cool about it is that I can put in the name of the employer or the union and pop up a list of every retirement plan offered by that employer or union. So we know we're not missing anything. And we often, in working with our legal aid partners, find plans that weren't disclosed, that the client didn't know about, that sometimes even the other party didn't know about because a lot of people don't really understand their retirement benefits. Sometimes they're hiding it on purpose. I've been a family law lawyer a really long time. but oftentimes they genuinely don't know. We also help prepare notices of adverse interest, which essentially is a notice of pending action that you send to the retirement plan so that the retirement plan is on notice that someone other than the plan participant, right, the employee spouse or member spouse, has an interest in those retirement funds. And most plans, in response to a notice of adverse interest, will place a hold on those retirement benefits, not allow withdrawals or retirement, or loans to be taken out from those plans.
Except for military. Yeah,
Well, we're going to cover that because TSP you can, but
yeah,
the
that's true.
pension you can't. Yeah. We also help prepare judgment language. So the language that's in your judgment is really, really crucial. The quadro effectuates what's in the judgment. So if the language in the judgment is unclear or vague or omits a plan or doesn't name the plan correctly or there's some other kind of problem with it, that can cause huge issues for your clients. We see it all the time where a plan wasn't named correctly or survivor benefits weren't specifically awarded. And then the worst happens, like the other party passes away. And then clients call us, and we have to tell them that because their judgment language was not clear enough, there is nothing that we can do to help them access their share. They have lost it. And everyone always cries on those calls. So we would like to avoid them very, very, very much. So we prepare judgment language that is specific to your case and specific to the type of plan. So our judgment language for military is different to our judgment language for a 401k because we know what those different plan requirements are. Then we also do some calculations. If we're trying to figure out what portion of a plan is marital property, then we can sort of talk through different calculation options that we might offer. The center is lucky enough to work in several states, and we have a really great advisory council made up of a number of national experts. John Camp, for example, is a military expert licensed here in Florida who participates in our advisory council and helps us out when we have any questions about anything particularly complicated, although he does keep threatening to retire. So, but in his retirement, he's going to stay on our advisory council. And we do all of this work using technology donated to us by Quadro Council. So that's how we have access to that, big database of plans. And then when we prepare our quadros, we can do them very, very quickly because we use a software program that Louise and Natasha and others designed. Sometimes I refer to the software program as like having Louise in your computer, which is really nice. That's a great benefit for us at the center. Okay, so let's talk specifically about military retirement. So for the most part, there are two retirement plans that we're talking about when we're talking about military retirement. A defined benefit plan called the Armed Forces Retirement System, and a defined contribution plan called the Thrift Savings Plan. And a defined benefit plan is what you think of when you think of a pension plan, right? It pays out a specific monthly amount starting from retirement, usually for the rest of someone's life. Um, Defined benefit plans are not so much like a pot of money in an account. It's more like a right to participate in a stream of income, right? So you have this right, and it's a very consistent stream of income on often a monthly basis. So this is the traditional pension that we're thinking of. The thrift savings plan, by contrast, is a defined contribution plan. That's sort of your 401ks are a defined contribution plan, 403bs, profit sharing plans. The defined contribution plan is much more like a pot of money in an account. But that pot of money is not like a bank account. It's a pot of money that's invested in the market, right? And so it'll experience earnings or losses depending on how those underlying investments go. Um, Very technically, the orders dividing both of these plans are not called quadros. For the Armed Forces Retirement System, it's called a Military Retired Pay Division Order. And for the Thrift Savings Plan, it's called a Retirement Benefits Court Order. Today, we're going to just call them QDROs. That's what everyone says. Technically, they're not qualified, but we're going to call them QDROs today because that's sort of the colloquialism at this point. But just know that technically that's on a caption page. That's not what it's going to say. Some of you might know from working with QDROs in the past that if a plan will take a look at a draft QDRO and sort of give us its seal of approval, we always want them to do that because retirement plans can reject an order from a court if it's inconsistent with the retirement plan's procedures. And that can be surprising sometimes for parties and for their lawyers who feel like, but I have a court order, a judge signed it. It's certified. it's a real thing. And the retirement plan does have the power pursuant to federal law and some state law to just take that court order and throw it in the trash if they don't like it. So we really always want a plan to take a look at a draft QDRO. But for the Armed Forces Retirement System, for the pension, they do not pre-approve QDROs. They do not look at drafts. The military is like, send us the final or send us nothing. However, for the Thrift Savings Plan, that plan does offer pre-approval. So we always want to send the QDRO for TSP, for Thrift Savings Plan, to the plan to look at. Like Louise said, notices of adverse interest, which place the plan on notice that someone else other than the participant has an interest in the plans. The pension does not honor those. They are like, we're not doing that. We don't pre-approve. You send us the final and that's all you get. The thrift savings plan, though, you can send a notice of adverse interest. So if your client is worried about, money being taken out or disposed of, or a withdrawal or something like that, we want to send a notice of adverse interest, ideally very early in the case. Today, you might hear me, Louise, and Natasha use a couple terms of art. We're going to try really hard not to do that. But you might hear us talk about the participant spouse or the member spouse. That's the in spouse. That's the spouse who's the military member. And then you might hear us talk about the former spouse or sometimes the alternate payee, AP. That's the out spouse. That's the spouse who's not the military member who's getting their marital share of the retirement plan. Participation in the Armed Forces Retirement System and the pension is mandatory. Participation in a thrift savings plan, the 401k style plan, is voluntary, but the vast majority of military members participate in the TSP. So it's a very rare case where a member has not participated in TSP. It does happen occasionally, but the vast majority of members contribute to it. Okay. So we're going to do just one slide on the thrift savings plan because the pension is so complicated. That's really where we're focused today. The thrift savings plan, the division is pretty similar to other kinds of defined contribution plans like a 401k. There might be some separate property issues to kind of keep an eye on. Does somebody have a premarital interest that's going to need to be valued? Did somebody roll over some funds from a premarital source during the marriage? Those are kind of things to think about. And most importantly, the notice of adverse interest is going to be honored. And we really suggest sending those early and often in cases because we have seen the bad things that happen when the plan doesn't know that the parties are getting divorced, right? And oftentimes the plan has no idea that these people are getting divorced. And so if the member shows up and says, I want to withdraw all my money, the plan has no reason not to allow that. And in some cases has to allow it unless they have specific notice that someone else has an interest in those funds. Okay, so let's turn to the pension. I want to give a quick caveat here for pension related to service members who entered service prior to September 1, 1980. The rules are ever so slightly different for those members. At this, place and time, at this date, we rarely see cases where the member entered service that long ago. So today, because that kind of is a whole additional level of complication. We're not going to be talking about those service members. The vast majority of cases that we see, the member entered service after September 1980. So we're going to focus on the rules about that. Okay, so the first thing that we need to know to prepare the QDRO is the branch of service that the member was in at the time of divorce. So it's super common for members to switch between branches during their career, but for our purposes, for purposes of the QDRO, what matters is the branch at the time of divorce. And people kind of expect, right? Army, Navy, Air Force, Marine Corps, Coast Guard, those members all participating in the military pension. That makes a lot of sense. Sometimes people are surprised to find that members of the Public Health Service and the National Oceanic and Atmospheric Administration, NOAA, members of those two organizations also participate in the military pension. So if you have a client or an opposing party who is employed by either of those, they may also have that military pension right. Okay. There's going to be a little bit of alphabet soup. I know you guys just did, it sounded really cool when Jorge was telling me about it, your like acronym game show webinar. That sounds really fun. I'm going to have to catch that one on YouTube. We got some acronyms for you today too, in addition to QDRO. So you might hear us say the SBP, that's the Survivor Benefit Plan. And the last part of the presentation is all about the SBP and how to secure it. You might also hear us say the DEEMS, and that's the member's date of initial entry into military service. Remember, even if they were in a different branch or in reserves and then went active, or active and then went reserves, we need that initial entry into military service to prepare the QDRO. We're also probably going to talk about the LES, which is the leave and earning statement, essentially a pay stub for a member of the military. You might also hear us talk about DFAS, which is the Defense Finance Accounting Service. That's who administers QDROs and the pension for the Army, Navy, Air Force, and Marine Corps. It's interesting, actually, the Coast Guard has its own separate pay and personnel center that administers for the Coast Guard and the Commission Corps of the Public Health Service and the NOAA. But the vast majority of military pension cases that we deal with are Army, Navy, Air Force, and Marines, and those go through defense. As I mentioned, member is the in-spouse, former spouse is the out-spouse. That's how you're going to see it usually in the military pension QDRO. And is probably what we're going to say today, member spouse a fair amount. Okay. So we're going to talk through some military concepts using a hypo with some particular dates, because dates matter a tremendous amount for military pension purposes. So our hypo is Jane and Juan. So Jane enters military service January 1, 2005, right? She marries Juan. It's on February 14th on Valentine's Day, 2010. Very sweet. Jane files for divorce on February 15, 2019. So that last anniversary did not go well. Their divorce judgment is entered exactly 1 year later, which is, a little bit of ease for all of us. Was entered on February 15, 2020. And then Jane has only ever been active duty, sending things kind of out into the future. She's going to retire in 2030 after 25 years of service. Okay. So we're going to use these dates and this hypo on the next slide to kind of talk through some of the military pension issues. Okay. So basic concepts for the military pension. The first thing to think about is what we call the 10-10 rule. And essentially, for a former spouse, for the out spouse, to receive payment directly from DFAS, 10 years of the marriage needs to overlap with 10 years of the member's military service. And what can be a little bit tricky here is that those 10 years are measured from date of marriage to date of divorce, right? So Jane and Juan marry February 14, 2020. Their divorce judgment, they are divorced on February 15, 2020. So they have met that 10 years just barely. Now, if they hadn't met the 10-10 rule, that does not mean that the out spouse has no interest in the military pension. It just means that DFAS is not going to pay the out spouse directly. DFAS is like, we don't want to deal with you unless it's been 10 years. But then we have to kind of figure out how that pension is going to be paid out, and you don't do a QDRO. It sort of has to come from the in-spouse. So for direct payment from DFAS and doing a QDRO, we need to make sure that that 10-10 rule has been met. Military QDROs are all what we call shared interest QDROs.
Carrie, I just want to interject really quickly on the 10-10
Yeah.
rule.
Yeah.
And this question comes up when the issue is that it's under 10 years, and what to do, especially if the member has less than 20 years of service, because 20 years is when the member vests and is eligible to start the retirement. And excuse me. And so it's a problem in terms of valuing that interest under 10 years, what to do, how to handle it. That's a whole other area of topics to discuss. But I would just say, generally speaking, just remember they don't lose their right to that share of the asset. And I guess the majority of people just reserve jurisdiction to the date of the member's retirement to then determine what the member can pay over to the non-member. But some people just guesstimate on what if it's a very short marriage is particularly on a number, because there's no valuation that can be done because they're not vested. So another thing that happens is some people at the time the member retires then pursue the funds as support if the court allows that in the jurisdiction. And in that case, with support, the 10-10 rule does not apply. So those are just little tricks around the 10-10 rule when that situation comes up.
Thanks, Louise. Okay, so every military pension QDRO is what we call a shared interest QDRO. And that's contrasted with something called a separate interest QDRO. And essentially what a shared interest QDRO means is that the out spouse, the non-member spouse, receives a share of each monthly payment once the member spouse retires. So there isn't an ability for, in a separate interest QDRO, what we do is kind of set up for the non-member spouse like their own sort of little pension with the pension plan. Not possible for the military. The military is like, we're not doing that. They only do shared interest. So the non-member spouse is going to start receiving their benefits from DFAS when the member spouse retires. They can't do it before. And they're sort of sharing in what that member spouse receives. As Louise mentioned, vesting for a military pension is fairly different than your private pension. So a member isn't vested in their military pension until they've done 20 years of service. And essentially what that means is that if they leave prior to that meeting that 20 years, they do not receive a pension. In most private pensions, vesting's like 5 years. So the military really has an extended time period that they require members to be in service in order to receive this significant pension award. And then it really matters a lot for our purposes whether a military member was only ever active duty or if they were ever at any time for 1 month in the reserves, which would be a unique case that someone was in the reserves for a month, but any even little amount of reserve service period, that really matters. And we're going to cover the difference between active versus reserves in the next couple of slides, but it matters for us tremendously. So you're all probably familiar-ish with the time rule, right? Which is how military pensions are divided as well. We take the sort of marital time in the plan over the total time in the plan through date of divorce or date of retirement. Um, but how we calculate time is different for if someone was active duty versus if they were in the reserves. So if they were active duty, it's much easier. You'll see there's like one line on the active duty side of this slide. Time is based on their months of active duty. Much easier, so simple. If the member was ever in the reserves, time is going to be based on points. And points are different based on what that reserve member's service looked like. So how you can't sort of make a guesstimate based on, well, this person was in the reserves for X amount of time, therefore they have X amount of points. No, because every reservist service looks different because they get different amount of points if they were called up to active duty. They get different amount of points for certain drill periods. They get different amount of points for their reserve membership, so on and so forth. So it's super, super fact specific what number of points that we are dealing with. A reserve member has to have a minimum of 20 qualifying years to be eligible for the pension. And then we want to clue you all into this concept of something called a gray area reservist, which can sometimes get very confusing for people. So sometimes after someone has done their 20 years in the reserves, they will say to you, I have retired from the reserves because they are no longer actively drilling. They are no longer a member. Um, but for our purposes, they have not actually retired until they start receiving their pension. Most reservists start receiving their benefits at age 60. So if somebody joined the reserves at 20, got out at 40, between 40 and 60, when they start receiving their pension benefits, they're what we call gray area reservist. And this might be confusing because the member is often going to say to you, I'm retired from the reserves. And that's a perfectly reasonable thing for them to do. But for our kind of term of art purposes, they are not actually retired for purposes of preparing the QDRO. Gray area reservists will often have something called a 20 good years letter, stating that they have served their 20 good years and are eligible for the pension. But they are not yet receiving those benefits. So they are not retired for our purposes. So just because someone says they're retired from the reserves, ask follow-up questions. Do not accept this as meaning they are actually retired. Okay, so the next concept we're going to cover is something called the high three, which we need in certain cases, and we'll talk about when we need it and when we don't. We love the cases when we don't need it because it's an additional level of kind of complication to figure out the high three. So the high three has to go in the QDRO, has to be in there. And it is the average of the member's highest 36 months of gross basic pay prior to the date of divorce, right? Average of their highest 36 months, highest 3 years of gross basic pay prior to date of divorce. If someone was only ever active duty, it's most likely that it'll be the last 3 years just preceding the date of divorce, right? Because as they serve for longer and they, experience promotions, they are earning more as time goes on. For a reserves member, it's a little bit more complicated, right? Because if they were called up to active duty 10 years ago, 15 years ago, that time period may have included their highest 36 months of gross basic pay, not the time period just before the divorce. So it gets a little bit more complicated for a reserves member. And for a reserves member, those 36 months might not be consecutive, right? They might have been called up to active duty and then not, and then called up again a couple years later and then not. So for a reserves member, it can get a little bit complicated to get the high three calculated. And so this information about the highest pay can be found on the member's LES, the leave and earnings statement, for each of those 3 years. If it absolutely cannot be obtained, and I will be honest with you, in most of the cases at the center, we do not have access to 36 months of leave and earnings statement. It's just not something that our clients have, that they have access to. Um, Subpoenaing the military is not necessarily a fool's errand, but a real, a real big challenge. So we can do our best estimate with information provided by the Department of Defense, so long as we have the pay grade. So if we know someone was an E8 or an E6, we can sometimes figure that out, but it's only going to be an estimate. We'll do our best, but without that LES, we can't get at a real precise high 3. Natasha, Louise, anything you all want to add about the high 3?
Yeah, I'll add something in. Thanks, Carrie. So especially for reservists with the center, I see that most litigants cannot provide the LESs. So using the pay grade, even if we know that, let's say the military service member is an E6, we can make that estimate using that information prior to date of divorce. Even with a reservist, but it is, again, like Carrie said, an estimate, because the time that the military member was probably active duty was before that time. So it's an estimate, but it still gets us the information necessary to put in the order.
It's a real problem when they passed this law in 2017 that changed how the military does things, and I'm sure Carrie's going to touch on that in a minute. But it's a real problem because DFAS and the Coast Guard, I'm just going to refer to them all generically as DFAS, even though they're two different pay centers. They don't check it. They won't. And they don't want the administrative burden of figuring out what the hypothetical final average compensation is, which is the high 3, as of date of divorce versus date of retirement. So there are conditions that it's required to do this, and we do the best we can, and all of us across the country are doing the best we can with the information that we can get, mostly based on the DoD website and what their pay center calculates the basic pay, base pay. So I would just say don't freak out if you can't get that information, because we do have a way to estimate it, and in almost all cases that's the best we can do.
One thing I'll say also is sometimes when we're working with a legal aid partner, we've had some success in doing an estimate and then sending the draft quadro to the military member for review and signature. And then they're like, well, that's not right. We're like, great, give us the info that we can use to then calculate it more precisely. So if
yeah,
they
that's true. It does get the member on board, because if they don't think it's fair, they think it's too high, they're gonna all of a sudden miraculously come up with the statements which they
they'll
can
be
get
cooperative.
online.
Right.
So it's a problem, because if they just have disappeared, which is a lot of them, a lot of the members, they don't want to be involved until they see the impact that it could potentially have on them if they don't agree with the high 3 that we were able to come up with based on what we find on the internet with the DoD.
Yeah. So that has been successful in sort of getting us the information that we need. Ideally everyone's cooperating and working together and providing the information that's needed to calculate this correctly. But also, we've been doing this a long time, and that's not always how it goes. Okay. So as Louise mentioned, there was a new law passed in 2017. I guess it's not that new. It's 2025 now. But feels new still. Natasha and I added some very sad emojis because this law made our life really complicated.
Yes, it did.
So in the National Defense Authorization Act of 2017, it sort of created two categories of military quadro. And which category your case might fall in depends on the specific facts of your case. And the big difference is whether or not we need the high three. So if the parties were divorced on or before December 23rd, 2016, which is also like we couldn't have made it like the first of the year, y'all, like it has to be like a random day in December. So if the parties were divorced on or before December 23rd, 2016, or the member retired before divorce. So even if people are getting divorced now in 2025, if the member retired before the divorce is final, you fall into this first category. So if either of those things is true about your case, we need certain documents. If the member retired active duty only, right, never in the reserves, we need their DD 214, which is called the Certificate of Release or Discharge from Active Duty. If they were ever in the reserves, ever, we need their current chronological, or if they're retired, final statement of points. And again, remember those points are super specific to the individual member's service. So we can't really estimate points because it just so depends on what each individual service member's service history looks like. Excitingly, we do not need the high three. That really
Our
that
favorite
removes,
thing.
yeah, that removes a big barrier for us. And again, remember, retired for our purposes means having started to receive retired pay, right? So gray area reservists, if they're not actually receiving their retired pay, they do not fall into this category. Okay, the other category where unfortunately we do need the high three is all the new divorces. So if the parties got divorced after December 23rd, 2016, so anybody going through a divorce now, and the member's not retired or they retired after divorce. So if the parties divorced in 2018 and the member retired in 2020, we still fall into this second category, right? So you'll notice there's an or in big red letters on the left and an and in big red letters on the right. So divorce after 12/23/2016 and members not retired or they retired after date of divorce. We got to get that high three. So that's the challenge for
Yes.
quadro preparers all across the country. You know, Louise mentioned, you know, all the quadro nerds are kind of doing the same thing. Louise is part of a group, and I'm totally going to steal one of her jokes here. A
Yes.
group called the Quadrones, which she says is not a singing group, which is I fully stole your joke, Louise. But a kind of steady group of quadro experts nationwide, including actuaries and valuation experts who prepare quadros, as well as lawyers who prepare quadros.
Yeah. I mean, it's kind of was shocking when they came out with this. Nobody saw it coming. It was a member of Congress from Oklahoma that snuck it into this giant authorization bill, and all of a sudden there was no comment. I mean, it was really unbelievable how they were able to pull this off and then put the burden back on basically the former spouse to come up with information that they don't have access to. So it was maybe someday it'll be overturned, but it seemed like a pretty unfair standard for parties divorcing, both for the member and but in particular for the non-member, especially when the DFAS has all these records. They could do the math if they wanted to. They could create the computer software program to do it very quickly, but they won't at this point. They don't.
So similar on both kinds of cases, if the member retired active duty, we'd like that DD 214, their release or discharge from active duty. And then if they were ever in the reserves, we gotta have that point statement, either current chronological if they're still active, or final if they retired after date of divorce. We gotta have that point summary because that's one thing we really can't estimate. Okay. So let's talk about the impact of disability. In your materials is a Supreme Court case called Howell versus Howell. And the holding of that case is that funds paid as the result of a member's disability are that member's separate property. Even if the disability waiver was before the date of divorce or after the date of divorce, it occurred during the marital period, doesn't matter, it's separate property. So how does that affect how pension payments get paid out? The most common type of disability that we see is something called a VA disability waiver. There are some other kinds of disability, medical disability retirement, combat related special compensation, but what we see most often is a VA disability waiver. So, and that's going to come with a disability rating, which if you've worked on military cases or know military members, you may have heard before. I'm rated 30% disabled. I'm rated 100% disabled. So if the member is less than 50% disabled, DFAS, which is the organization that pays out the pension, DFAS is going to take the pension and reduce it by the amount of that VA disability, right? So the disability comes from the VA, and then the pension reduced by that amount comes from DFAS. Essentially, if you're under 50% disabled, DFAS does not allow you to kind of double dip. But that can be very hard on the former spouse, on the out spouse, right? Because their share of that pension payment has decreased because they don't get any share of that VA disability waiver pursuant to Howell versus Howell. But the pension payment has been reduced by the amount of that VA disability payment. So they're getting 50% or whatever their marital property percentage is of a smaller amount. If the member is more than 50% disabled, DFAS doesn't do anything to the pension. So the member is going to get their VA disability and also whatever their pension is, and the out spouse is, not going to be affected by that because they'll get their marital share of the full pension amount. So that's sort of the way that the disability ratings and the VA disability waiver affect the pension payment. Doesn't affect it if they're more than 50% disabled, but if they're 50% or less, then that pension payment is going to go down.
So again, when this happens, and sometimes it happens after the member's already retired and then has a disability come up, and then it reduces the pension and impacts the payments to the former spouse. So so some courts have litigated this issue across the country, and it doesn't, it's not a perfect solution in terms of additional funds. If it's a substantial reduction because it's under 50%, but let's say it's 49% or something like that, then it still could be a big hit to what the monthly benefit would be. Without it, is to again pursue support, because if you're looking if the total circumstances and of marital property and marital assets and equity and all that stuff, if the court's going to look at all of that, the totality of the circumstances, they may want to award support for this loss of income that they would normally get for retirement. So it just depends on the facts of the case in the court.
Okay. So let's talk about the survivor benefit plan. And this is one of the most kind of technically tricky parts of this, right? There's a lot of stuff related to the military pension that we can work to kind of help resolve even post-judgment. We can do estimates for the high three, we can kind of do as much as we can.
Hey, Carrie, I'm sorry to interrupt again. Before we go, since we have the time, I'm going to kind of deep dive a little bit more here. For practice tips is try, and if somebody comes to you and the other side is reluctantly willing, usually it's a man, but it could be a woman, that before they disappear, try and get all these records we're talking about upfront in the case from the member, who can get it online very easily. You don't have to know whether you're going to need to use it or not, but I would say, especially the point summary, the DD-214, and LES is close to the current time period. is going to help in all these situations, depending on the facts of the case. Because a lot of times, when we get the case is after divorce, and the member has no incentive to help or to get these documents to us. And it's very hard to subpoena. It has to be a court-ordered subpoena, and there's some rigmarole you have to go through. I mean, it is possible. It's a lot easier. It's virtually impossible if you're a federal employee and trying to get something out of OPM. So we like DFAS over OPM if we have to like pick a side. But but I can't, then we'd start doing the guesswork because that's the only thing we can do to protect the rights. Is what the judge, we tell the court, they're like, oh yeah, well, this is what the best we can do if the member's not going to cooperate, especially if the member's disappeared post-divorce, which is when most of these get done. The other practice tip is try, if it's possible, to file the file the QDRO for the military concurrent with the divorce judgment, because then you're done. You've got all the information you need and the rights are protected. There's that window when after divorce, before the QDRO is done, where the member can do bad things or can die, and it could ruin the opportunity for the survivor benefit. It could ruin the opportunity to protect the rights, depending on the member and how they retire, especially we'll get to the survivor benefit plan. So I really encourage you guys to do that and work with our office on getting really good case-specific judgment language for military, because we can find out a lot of that information beforehand, and it's better to flush it out before than to have to deal with it after retirement. I know you get cases at any point, post, prior, and etc. But if it's at all possible to get everything tied up with a nice bow by the end of divorce, especially for military, we try to do it for every case, and we always encourage. So it's our mantra to judges all over the place: do not let them divorce till you get the QDROs done, because it just makes it's actually a huge burden for the court system to have to keep pulling up these cases. There's no statute of limitations on getting a QDRO. They can pull up cases from 20, 30, 40 years ago in their court. I mean, it really clogs up the court system. So you're doing the judges a big, huge favor by trying to wrap all this up before divorce.
Yeah, that's a really good point, Louise. Yeah,
Are there any questions? You guys are being so quiet. We love questions because we're just like talking to a screen, but we love answering any questions, and we do have the time, so we're excited to be able to answer any questions.
Yeah, those are really good practice tips, Louise, especially because the military pension is not going to pay attention to a notice of adverse interest, right? After judgment, there really isn't any protection. So especially for the military, that's the one where we really, really, really encourage and suggest that QDRO be done concurrently with the judgment, because we see those big problems that happen when there's a gap. And it's really, we would love to have fewer calls where we have to tell people they lost their pension benefits because the QDRO wasn't done, because everybody is crying, and it's really, really hard.
It's a tragic situation when, a out spouse is calling saying, oh, I'm entitled to this. And then I have to break it to them that unfortunately their rights weren't protected in the process, and then they can't receive anything. That is a terrible feeling. They're crying. I want to cry. It's very sad. So
yeah, I've been doing QDROs pro bono since 2004, because I saw this gap, and most people don't even realize that. They think, well, why do legal aids need QDROs? Why do and because you've got one spouse that is perhaps working and there's retirement, and it's often it could be a very substantial retirement that provides a monthly income. I have this one experience, I'll never forget it, where I did a QDRO as a Teamster as a member, and the former spouse was living in her car with her kids and found the legal aid that I was working with doing free QDROs, the Harriet Buhai Center for Family Law, and I was able to. I just did the work, and I found out afterwards the outcome. But we were able to get her a Teamster's pension. Her share was $3,000 a month paid to her for the rest of her life. That got her in an apartment. She went back to school. I mean, she was able to start her life, and she was entitled to that. She didn't even know about it. She didn't know her right to that. So I've been advocating for getting access to QDROs. That's why it's called Center for Access to QDROs for a long time. And this nonprofit is the culmination of all that work. And it's, our intention is to have this nationally available to anybody who's in need. And obviously we need to get the funding for that and all that stuff. But this is really an important area. This is real money that goes into people's pockets. And the need is so important. And it's overlooked by, probably because people don't want to deal with it. I don't blame them. But that's why we started the technology company. That's why I started this in 2017. I started the technology company because I thought, before I retire, which I'm not going anywhere anytime soon, but before I retire, I want to fix this problem. It's a very broken system when it comes to retirement benefit division for everybody. 80% of the population across the United States doesn't go to a family law attorney. They just go to court, and then the judges are overwhelmed with all the pro pers that are in court. So it's a problem we're trying to fix. So thank you for letting me get on my little soapbox here for a moment. So we have a few minutes here still to talk, but I just want to kind of bring that home. I see a question. How do we go about getting your help for legal aid? Well, call us. We're working on getting funding from Florida. We'd love to work more in Florida. We've got John Camp there too that can help us with any particular, but we do QDROs in Florida for QDRO Council, so we're very comfortable working in Florida, and we'd love to be able to get funding and work with the legal aids. But if you have a particular question, just give us a call or sign up for our newsletter. You'll hear about upcoming talks that we're doing, and we'll just keep working with the powers that be in Florida to try and get the funding that we need to be able to work directly with all the legal aids in California.
And I will also post our contact information in the chat, so you can reach out to us directly.
All right. So the survivor benefit plan, and this is, I put out the slide, a walking track for the unwary, because this is the part of the military pension issues that sometimes becomes unfixable if it's not handled properly and correctly, especially in the judgment. So this is where we see problems that we cannot fix. So this is, hopefully you're paying attention and into the whole webinar, but if you're like zoned out, zone back in for this part. This is a really important piece of this, because this is what often gets mishandled. I'm a family law attorney. I love family law attorneys. We have a lot going on in our cases. There's a lot for us to keep track of. And in a military case, there's many even more things to keep track of. And the survivor benefit plan is one of the really, really crucial ones. Okay, so the survivor benefit plan, I think this is sort of a hard concept for sometimes as family law attorneys to understand, which is that for most pensions, the pension payment that's paid while the member is alive, from the perspective of the pension, is different than what happens after the member dies. I think for family law attorneys, we think, oh, we got our client their marital share, and that just kind of is what it is. But what happens after the member dies is very different and very specific to each pension. So the survivor benefit plan is what would pay the outspouse, the non-member spouse, after the member's passing, right? So we really want to be careful about how we treat the survivor benefit plan, because we don't want to get into a scenario where we've made a mistake and we haven't secured the survivor benefit plan. The member dies, and your client, if your client's the out spouse, their benefits cease, their benefits end, and there's nothing we can do about it. So we want to be very thoughtful about the survivor benefit plan. So the survivor benefit plan pays one eligible beneficiary. So you get like one bite at this apple. You don't get to name like a partial beneficiary and then a contingent beneficiary. You get just the one. It does cost money, right? The survivor benefit plan is it's not exactly like an insurance policy, but that's sometimes a way to kind of help think about it. There's a premium for it. And that premium comes out after the member retires. It comes off the top of that pension payment. So sometimes people want to get specific about who pays the premium for the survivor benefit plan. And people that do some military cases want to say, well, the out spouse has to pay the premium for the survivor benefit plan. That adds so much complication because there is not a way for DFAS to assign the entire cost of the survivor benefit plan to the out spouse. It comes off the top of the pension payment, and then the pension is divided. So if we're going to assign it to one party, then you have to do a whole nother calculation to figure out what that person's share should be, incorporating the premium cost of the survivor benefit plan. So for the most part, if you cannot do that, that would be best. that would be, it just makes it so much more complicated. And I think sometimes people that represent a lot of military members are like, well, the other person should pay. It's a benefit that they will receive. But most courts across the country have found that it is fair for the parties to share that premium cost, because if the non-member dies before the non-member share reverts to the member, right? The non-member doesn't get to leave their share to a beneficiary or anything like that. By federal law, it reverts to the member. And so each of them potentially gets a benefit if the other one predeceases them. And just that the additional complication of calculating what the out spouse's share should be if they're assigned the entirety of the SBP premium is rarely kind of worth the savings.
One thing I'd like to add, if you do have a case like that, feel free to reach out to us, and then we can tell you what information is needed for that type of calculation. It's not ideal, but we can still do it. We will do it for you. But it does add that additional layer of complication if you can avoid it.
But it's also not possible to do the calculation of the offset for the cost of the survivor benefit plan to award 100% of it to the former spouse until the member retires. And so you basically have to plan to go back to court at that time, unless they're already retired. It's not possible to do that calculation because we don't know what the numbers won't be there in terms of figuring out what the share should be of the cost for the survivor benefit plan, because you don't know how long they're going to be working. So then, I mean, it's a two-step process. We can do it, but like Carrie said, it's basically when it comes off the top, it's a pro rata cost to both sides. And most people find that that's good enough, fair enough. There's some weird, funky calculation in a case in California that people rarely use to calculate an offset, but it does require the non-member, the member to pay a share. The court did come down in that case and said, yeah, they need to pay something because they're getting a benefit if the former spouse dies before the member. They're going to get 100% of the pension as if, and that's not a fair outcome for any type of asset, that it all goes back to one side versus staying with the side it was awarded to. So I would say we bring this up now as in the forefront, and maybe in your cases they're not even going to think to ask about this type of question. We do get the members all of a sudden get very keenly involved, especially if they're especially if they're like engineers. The engineers are the worst.
Engineers will also have their LES from when they were called up to active duty
Yeah,
25
yeah.
years ago.
They
So
have the
the
LAS
engineers
back in
have every record
1981.
back into time. Yeah.
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 So
Yeah.
that's
Yeah.
great. We love them if they want to give us that information and we can do the calculation. They can pay us a lot of money. But for the legal aid community, I don't think it comes out that much, but it still comes out. In fact, we just did one in Hawaii where it came up. And we're still helping the legal aid in Oahu with that problem. So just so you know, it's not a sure thing, but it doesn't come out. It's just something to be aware of. And I think in our materials, I hopefully do a good job explaining the pro rata apportionment and how that is in most cases good enough for most people. And we always tell people, retirement benefit division is never perfect. It's not possible to be perfect because you're dealing with federal law and state law, and there's this constant conflict between the two, and you just try and measure and try and get as close as you can for the state law to what is possible under the plan law, whether it's the plan law for the state or the federal. That's always going to preempt what the general marital property law is in the state.
Yeah, so hopefully this happens sometimes when it kind of just like gets slipped in and it's like, oh yeah, okay, that's fine, but it has kind of a ticking time bomb,
Yes,
especially if
definitely.
the member hasn't retired, because we can't figure out what it is until they retire. So the default amount that is paid to the SBP beneficiary is 55% of the member's, monthly pension payment of their retired pay. If the member retired at death, they must have elected or have been deemed to elect, we'll talk about that in a second, the SBP option at retirement. So you can't be retired for 5 years and then add on the SBP. You have to elect it at retirement or very early on in your retirement. This is not something that we can go back and fix if the member retired and didn't elect the SBP. So I always say to people that if someone's about to retire, that's like a 5-alarm fire in our office.
Yes.
We drop everything. That case skips the line. Sorry if you had to wait an extra couple days for your quadro because someone else's was for a member that's about to retire. And that's true for any kind of plan. Because when the member retires, they make elections. And those elections, in most cases, are not modifiable. So we really, if someone's going to retire, we really hurry and rush to get that quadro done for you all, because that retirement can affect negatively the out spouse's interest. And we're involved in a couple of cases at the center now that are being litigated related specifically not to military pension, but to other pensions, public and private, where the member retired prior to the quadro being done and made elections that have essentially made it so that if that member passes away, their former spouse, one of whom was married to him for like 30 plus years, will get nothing when he dies. So if he gets hit by a bus tomorrow, her pension payments stop. And there's nothing that can be done about that from the perspective of the pension because that person made their election. So if someone's going to retire, that's like alarm bells go off. And in part of that for the military is because they have to make that SBP election really early on.
One way that I explain it is with the survivor benefit plan. If you're not paying a premium, they're paying the entire pension to the member. And so there are no takesy-backsies. You can't go back and say, whoops, now I want to pay this premium. Even if you were to start to pay the premium, you weren't paying it for maybe a year or 2 years. So essentially no retirement plan will do that. Will pay out the full amount and then say, oh, okay, now I'll add another life expectancy to that for a survivor. So we really, that's our big alarm, pew, pew, like warning.
This webinar has sound effects. um, So the other thing about the survivor benefit plan is to secure the survivor benefit plan. One interesting thing is that the 10-10 rule does not apply. So if we want to award just the survivor benefit plan, that is something that's possible, even if the 10-10 rule is not met. That's a little bit of an additional complication there, but something to think about. If the 10-10 rule isn't going to be met for the pension payments, but we want to do something with the survivor benefit plan. But again, remember, it's only provided for one beneficiary. So if the member remarries, then that person's kind of stuck. If the member's not retired when they die, the former spouse receives 55% of what the member's monthly benefit would have been in most cases. All right, so it's really important that if we want to include the survivor benefit plan, if we want the outspouse to continue to receive pension payments after the member's passing, that we include that in the judgment. But we know that you all get cases, and I got cases when I was a family law staff attorney that are post judgment, where somebody else did the judgment, and you're like, this is not what I would have done. So we wanted to include a little flow chart here to help us assess like when and how we can still get at that survivor benefit plan. Okay. So first off, was the survivor benefit plan specifically awarded in the judgment? The outspouse is awarded their marital share, including any survivor benefits, including the survivor benefit plan. If we are lucky enough to receive funding in Florida, we will happily provide you our military judgment language, which is much better and much more specific about the survivor benefit plan. But let's say, yes, it's specifically awarded to the outspouse in the judgment. The next question for us is, has the member already retired? If they haven't, if they're still active and the SBP was awarded in the judgment, we got to get that QDRO done ASAP before retirement, excuse me. Again, as I said, Natasha gave you sound effects, which were very cute. That's alarm bells going off for us if someone's going to retire. We've got to get that QDRO done ASAP, even if the SBP is awarded in the judgment. We have to get the QDRO because the outspouse has to perfect their right to the survivor benefit plan. Putting it in the judgment is not sufficient. We have to perfect it. So let's say the member has retired, but they retired for less than 1 year. This is when we get a little bit of wiggle room. Not a lot, and it's not perfect. It's better to do it all and get the QDRO done at the same time as the judgment. That's still our line. But if the member's been retired for less than a year, we might have a little bit of wiggle room. So we're going to serve that judgment that awards the SBP along with some Department of Defense forms I'm going to talk about in a future slide. We're going to serve that immediately before we even do the QDRO, before we do one single thing. We're going to get out that judgment that specifically awards the survivor benefit plan and Department of Defense forms ASAP before they hit that 1 year mark. So that 1 year from retirement, that's the deadline to be thinking of. And we're going to do that QDRO as soon as possible as well.
So getting the certified copy of the judgment out with those DD forms right away, so important.
Yeah. Let's say the member's been retired for more than 1 year. Let's say the member's been retired for 1 year and 3 months, 1 year and 5 months, 5 years, 10 years. Sad red box with a sad face. Likely out of luck, likely nothing we can do to secure that survivor benefit plan, even though, right, you might say it was awarded to the outspouse in the judgment. The outspouse did not perfect their right in that survivor benefit plan. They didn't do the things that they needed to do to secure it, like getting the QDRO done and serving some Department of Defense forms. Therefore, even though it's in the judgment, if the military member's been retired for more than a year, likely there's nothing we can do. And even if we do the QDRO, if the member passes away, the outspouse's pension payments will cease entirely. So if somebody is relying on this as a form of income in their retirement to support themselves and their family, this is when the crying happens on the calls with us, because there's not very much we can do in this scenario. Okay, so let's say the judgment is terrible. You didn't do it. You inherited it. Somebody else did it. Judgment is not good. Doesn't specifically award the survivor benefit plan. Again, our key question is, has that member retired? That's, in most of these, the key question. Let's say no, they haven't retired, but it's not specifically awarded the survivor benefit plan. Do that QDRO ASAP before they retire. Again, what were your sound effects, Natasha?
Pew, 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 pew.
Do that QDRO ASAP. We can still secure it. We can still do it. We just got to do that QDRO with, like, before they retire. We got to get it done. We will drop everything to do it, but we got to get it done. Has the member been retired for less than 1 year? Right? They retired, but we haven't hit that 1 year mark. We got to do the same thing. Serve a certified copy. Natasha, that's a very good point. Certified copy of that judgment and the Department of Defense forms ASAP, as soon as you get the case, before that 1 year period ends, and do the QDRO. Now,
sorry, one thing I want to add.
Please.
If it wasn't awarded in the judgment, then you have to do the 2 DD forms so that the member signs, because it wasn't outlined in the judgment. Yeah,
that's a very good point. So the member will have to cooperate a little bit there, or you get an order that they sign it. Okay. So is a member retired? Yes, but they've been retired for more than 1 year. Again, red box, likely out of luck, sad face. So even though awarding the SBP in the judgment, yes and no, both have red boxes, it's important to include that SBP in the judgment either way, because if we're coming close to this 1 year deadline, we can then secure that judgment and the DD form without participation from the member, right? We can do it without the member having to sign anything. We can serve that judgment and a DD form signed only by the out spouse, not by the member, and secure their interest in the survivor benefit plan. It's not in the judgment, like Natasha said, we can't do that. The member has to sign a form. The member has to get on board or be ordered to get on board, which, if we're getting close to a 1 year deadline, might not be possible, right? So we always want to include a specific award of the survivor benefit plan in the judgment, if at all possible.
And just Carrie, I mean, this has been a mantra for every talk we give on every retirement plan. If the intention is, and in 99% of the cases it is, to award the survivor benefit of whatever plan it is, not just military, just some little clause in your divorce judgment will be sufficient in most cases to preserve that survivor benefit interest. This, especially for federal employees' retirement, that's another even more draconian effect if you don't mention survivor benefits in the divorce decree or divorce judgment. It's a big problem. So we always tell people, just in your language that you normally use when you talk about retirement benefits, or come to us, we'll give you really good language to make sure you get good survivor benefit language for whatever plan you're working with. But if you don't have time and you're using your normal forms, just including awarded this marital property of XYZ amount, and includes all survivor benefits. And we have different language that we can help you with for that. But just any reference with the word survivor in it is going to help protect the out spouse's interest in the event of death or the inability to get a QDRO done timely. Protects the interest.
Yeah, I think it's a really crucial concept that I don't know that I understood as a family law attorney, that the post-death pension payments are, from the plan's perspective, different than what's paid during the member's life. Like those are different things. So we have to, we
Yes.
can't just award a marital interest in the pension. We have to also award survivor rights. And I think, from a family law attorney perspective, you're like, well, that's all, that's their share of the pension, whatever. But plans are very draconian about this. So we have to include something, even a vague glancing reference to survivor benefits. Give us something to hang our hat on there. Okay. So let's talk about securing the SBP. We want to do this 1 year. That's our key deadline there. The outspouse's interest in the survivor benefit plan has to be perfected. Putting it in the judgment is not enough, right? That's good. We want that. I'm not discounting that at all. We really want it in the judgment. But specifically for the military survivor rights, they have to perfect that interest. There is a Department of Defense form called a deemed election form, which the member does not have to sign. So if we can get a copy of the judgment that awards the survivor benefit plan and this deemed election form, which is signed only by the non-member, that says, please deem the member to have elected the survivor benefit plan at retirement, that secures the survivor benefit plan. Now, I do want to give you a heads up that you might do all of this. You might bend over backward, ensuring that your client receives their share of the survivor benefit plan. And then your client falls in love again. And we're so happy for them. We're so happy that they have found love again. However, if they were not married to the military member for 30 years, right? Even if they're married for 27 years, which is a very long time to be married. Even if they were married for less than 30 years and they remarry before they are age 55, they lose the survivor benefit plan. So if your client's 54 and is like, I really want to get married, I'm in love again, that's great. Wait, wait until you're over 55, because you'll lose that survivor benefit plan. So just want to give everyone a heads up. And I think some outspouses don't realize this or understand this or are told this, so they are kind of surprised to find it out. So when they remarry, they were not married to the member for at least 30 years, less than 30-year marriage, and they remarry before they are age 55, they lose that survivor benefit plan. And I believe we put the statute that says that it's 10 USC 1450. So yeah, so that's we're so happy that they found love, but it has real big impacts on the survivor benefit plan.
The unique and I don't care, I don't know if you were going to get to this, but
No, please.
the one of kind of the unique things for the military versus the same law, which is very arcane and hopefully will become done at some point for both military and for federal employees. I don't know why it's even in there. But for military, it's different. It's a different law, different, and it functions differently and has different regulations than federal employees. And for military, for the survivor benefit plan with this remarriage situation, if the member it does remarry, and then at the date of death if the former spouse remarries and at the date of death of the member, the former spouse is single, that they either divorced again or their subsequent marriage, the husband or wife died, the other spouse died, then the former spouse is still entitled to the survivor benefit plan if it's awarded in the judgment or in the QDRO. So we always try and award it regardless, even if they're remarried, if before 55, because you don't know what the circumstances will be at the time that the member passes. And that if we don't want to cut off that right, if they're entitled to, especially if it's a very long marriage, The other thing that we know is done, and we can't really speak to it, we don't get involved with any of that, is that the former spouse that remarried, well, the husband or the wife, the member dies, they'll divorce their current spouse and be awarded the survivor benefit plan and then remarry at a later date. So is that a good thing to do or not? It's up to the parties. We don't get involved with it, but we know it happens. We know that happens. Because of the quadrones, we hear the talk of lots of different situations, and we've got some really other great military experts in the quadrones that have a lot of feedback on this stuff. So, so it's not irreparable if there is a remarriage, whereas for a federal employee, if you're dealing with FERS or CSRS, we'd love to talk on that. We talk about that forever. That's our biggest bane of our existence, is the dealing with OPM. But for the federal employee plans, if the former spouse remarries, that's it. There's no right to the survivor annuity that's offered by the federal government.
Great. So the quadro is not enough. We can do the best military quadro you've ever seen, but if we don't serve it with a Department of Defense form, the Department of Defense is going to be the DFAS, excuse me, is going to be like, what's this? I have no idea what this document is. I can't possibly process this without this special DoD form. So even when we do the quadro, we serve it with a DD form, DD form 2293, which is like any form: name, address, date of birth, date of marriage, social security numbers, that kind of info. It's not a complex form really, but has to be served with that quadro. And that's something we prepared the DD forms along with the quadros and everything else that we do, because we really want to do everything that's needed to actually get people their money. So we're not going to do the quadro and then be like, and fill out these forms. We handle all that. For the survivor benefit plan, if the spouses are cooperating, or if the survivor benefit plan wasn't specifically awarded in the judgment, and the member's retired and we need their signature, the form is DD form 2656-1. Which is the election for SBP coverage for the former spouse. But again, remember, if it's specifically awarded in the judgment, we don't need the member to cooperate and sign off. We can do a deemed election form, which is DD form 2656-10. Where the military will say, okay, there's a judgment that awards this to the outspouse. The outspouse has submitted this form and signed it. We will deem the member to have elected the SBP for them. So that's what I'm talking about when we talk about how we have to perfect the right to the survivor benefit plan. Just putting it in the judgment is not sufficient. We have to also let DFAS know about it with the form that they require. All right. And that, perfectly on time, 3 minutes early. We get very chatty sometimes, so this is very impressive. I'm very excited about this. So if anyone has any questions that they've been dying to ask, we're happy to answer them.
Yeah, the timing was perfect. By the way, love the sound effects. So I'm gonna steal some of those sound effects. I've been dropping some links into the chat. If anybody has any questions, feel free to use this time to drop those questions into the chat. In the meantime, I want to make sure I cover a few items. I did drop the CLE code in there. I'm gonna read it out loud. It's 2507791N. I also dropped a link for the materials, which include a copy of the slides and the statutes that were mentioned. All of this, don't worry if you can't access it right now through the chat, because I'm going to include it through the email, and I'll also include these through the YouTube description. Same thing with the contacts. I'll add all the contact information for all of our speakers in that email, so you can reach out to them. Let's see what else we have. I want to take this opportunity also to thank our friends from the Center for Access to Quadros for coming back and presenting this. If you missed the first presentation back in April, I will also include that link in the materials that that we shared earlier. And I will also include that acronym game show link recording if you want to take a look at it and have
I
some fun.
want to
Yes.
see
So,
it.
I do too.
Yeah.
Yeah.
When it comes to quadros, I think one of my favorite things about this webinar and the previous one is that I think this really gives us that knowledge that has that lasting impact for our clients, not just like one individual case, but that long-term financial security that we often cannot just achieve with the typical services that we provide. So I think that's why this type of training and service is truly special. In addition to thanking, our friends from the Center for Quadros, I also want to give big shout out to Tanisha Hall and Bethany Barber from our friends at Legal Aid Society for the Orange County Bar Association, because they actually connected us with Carrie, and that's why we've been able to have these amazing presentations. So I know this is a really complicated topic. I want to make sure that people know about the website and the LinkedIn account, so I will include all of this in that email. Make sure to bookmark the websites. Make sure to subscribe to the newsletters, and to follow on social media. I follow their social media, their LinkedIn account all the time, and they have a lot of great webinars all the time. So make sure you don't miss out on those. And that's one of the reasons that I'm able to connect with them. So be on the lookout for that. So I do
Yeah.
see a lot of
And can
thank
I
yous.
just say, oh yeah, you guys have such a great resource in Jorge. Working with Jorge is like a dream. Anytime you want us back, we will be here. Jorge is wonderful. An incredible gift to the Florida legal aid community. So
Thank you. Thank you.
it's true.
Well, I see a lot of thank yous and a lot of appreciation. So, if anybody has any questions that they were unable to ask, feel free to email me. I'll share the contact information for our amazing speakers. So, thank you all again for joining us, and thank you, our speakers, for another amazing presentation. So, I'll take you up on your offer and probably call on you to do another webinar, because you do an amazing job. So, you killed it. Love it. And as I said, I'll steal some of those sound effects because they were really fun. So,
Welcome.
all right.
Awesome.
Thank you,
Thank you all.
everyone.
Thanks,
Bye-bye.
everyone.